Need help handling disciplinary issues at your company? Well, this video will guide you through a typical disciplinary procedure to ensure you handle it correctly and fairly. Hi there, Nicholas Campion here from First Formations, the UK's leading company formation agent. Any company that employs staff is likely to need to carry out a disciplinary procedure at some point. Small businesses that have not carried out disciplinary procedures before should be prepared to deal with these situations correctly and fairly, because they may be used as evidence of a fair process at an employment tribunal at a later date. In this video, we'll guide you through a typical disciplinary procedure and the key things an employer should do to ensure they protect themselves from falling afoul of employment laws. Let's start with informal measures. In the first instance, you could consider an informal approach. This may be a suitable option if the matter isn't of a serious nature and can be used to handle recoverable issues like persistent lateness, missed deadlines, or performance-related problems. If the issue relates to performance, the most common informal procedure is to place the employee on a performance improvement plan, or PIP. This plan outlines what issues have been identified and what the employee needs to do to improve. You should document these meetings and outline what steps you're taking to help the employee meet their targets. It's recommended to meet with the employee at the start of the PIP, halfway through, and again at the end of the 2-week plan. After the PIP, provide a final document of their performance and explain whether they met or missed their targets. For non-performance issues like sickness absence, a verbal warning may be more appropriate, warning the employee that future patterns of absence could lead to formal disciplinary action. So what about the formal disciplinary procedure? If the issue remains unresolved or there's a more serious allegation such as misconduct or gross misconduct, you should proceed with a formal disciplinary procedure. The first step in this procedure is to gather evidence to support the allegations. The person carrying out the disciplinary hearing should start by compiling all evidence required to support the allegations against the employee. This evidence should be comprehensive and compiled on the basis that an outside party, such as an employment tribunal, may be lay people and may not have an in-depth knowledge of your company's processes. For performance-related issues, this may comprise documentation relating to a performance improvement plan in which the employee has not reached their target. It may also include quantifiable data showing the employee's performance as well as their colleagues' performance in a similar role to act as a fair comparison to an outside observer. For sickness absence issues, this may comprise evidence of the employee's sickness absence record. It should also include confirmation as to whether the absences were self-certified or certified by a medical professional. For misconduct or gross misconduct issues, you should include witness statements from relevant employees. You should also use any other supporting evidence, such as statements from the company's IT department, call recordings, or footage from CCTV, etc. Once you have gathered all the evidence, you need to schedule a hearing to investigate the issue. In preparation, you must let the employee know that a disciplinary hearing will take place. Notice should be given in writing via an invitation letter. You should also enclose copies of any documentary evidence supporting your allegations, which will be used at the disciplinary hearing. The invitation letter should explain the allegations which led to the employee being invited to disciplinary, possible consequences, such as a final written warning or dismissal, their right to be accompanied by a colleague or trade union representative, and the requirement for them to inform you in advance if they wish to be accompanied and by whom. The time, date, and venue of the hearing. The hearing should be held at least 3 working days after the delivery of the letter to allow the employee to arrange for a companion to attend. However, the hearing should be held no later than 2 weeks after the letter to avoid unnecessary stress. And the identity of the person who will be attending on behalf of the company in the capacity of the decision maker and note taker. Finally, depending on the severity of the situation, you may consider suspending the employee on full pay in the run-up to the hearing. You should only consider this where the allegation, if proven, means that the employee's position in the company could prove immediately untenable. You must not suspend employees without full pay, as this is contrary to the Wages Act of 1986. So now you need to carry out the actual disciplinary hearing. This is where you meet with the employee to discuss the allegations and hear their version of events. The employee's companion, if requested, and the company note taker who will complete the minutes should also be present. The person conducting the meeting should introduce all parties present and explain the possible outcomes of a disciplinary hearing. They then need to go through the allegations and evidence supporting the allegations. Next, the employee may provide their comments on these. Once the employee has presented their case, you should adjourn the meeting to consider what outcome you've decided to issue. Outcomes should usually be delivered within 1 working day to prevent any unnecessary stress being caused by a delay. You should not provide an outcome within the same meeting. That comes after the meeting. Once the meeting has concluded, you can make the decision. You should be as fair as possible in assessing the evidence put forward. There are typically 6 outcomes you may issue after a disciplinary hearing. The first one is no further action. This is where you have deemed no penalty should be applied. Remember, with such an outcome, the disciplinary cannot be mentioned formally against the employee at a later date. The second possible outcome is a verbal warning. This lowers the threshold for the employee to be called to a future disciplinary hearing for a similar reason within the foreseeable future, which is in the next few months. Then there is a written warning or final written warning. These lower the threshold for the employee to be called to a future disciplinary hearing for a similar reason within the foreseeable future. It remains on their personnel file for 12 months and can be added to subsequent disciplinary hearing outcomes to provide a more severe penalty. Next is dismissal. This is where the employee has met the threshold deemed by the company that they can no longer be employed. The company serves their notice of employment, which will end at the end of their notice period. You would only dismiss someone for this reason after they had a written warning and a final written warning on their personnel file. The reason for this is to appear reasonable to an employment tribunal. And finally, there is dismissal for gross misconduct. This is reserved for instances where an employee has carried out an act that would make their position in the company untenable. This includes committing a criminal act or bringing the company into serious disrepute. Your company handbook and employment contracts should state that an employee dismissed for gross misconduct is not entitled to their notice period pay. You will not need to pay them for their notice period, and their final day of employment for payroll purposes is the dismissal date for gross misconduct. Now, you must deliver the outcome to the employee. Once you made your decision, meet with the employee to explain the outcome and any ramifications. Confirm everything in writing and let the employee know they have the right to appeal. So with all that having been done, let's take a look at what happens after the disciplinary procedure. Following the disciplinary procedure, there are several things that you, as the employer, need to consider. First up is the appeal process. The employee has the legal right to appeal if they disagree with the outcome, the way the investigation was handled, or if they have new evidence to submit for the case. The way an employee appeals should be cited in the letter to the employee, confirming the outcome of the disciplinary hearing. If an employee appeals, another employee who is not subordinate to you will need to hear the appeal. They will also need to carry out another investigation if necessary, consider an alternative outcome, and inform the employee of the decision in writing as soon as possible. Then there are employment tribunals. Employees with less than 2 years of continuous employment do not automatically have the right to take their case to an employment tribunal. However, if they have a protected characteristic under the Equality Act of 2010 and can demonstrate that their dismissal was discriminatory, they may still have a case. Protected characteristic includes age, gender reassignment, being married or in a civil partnership, pregnancy or maternity leave, disability, race including colour, nationality, ethnic or national origin, religion or belief, and sex or sexual orientation. You should consider these protected characteristics before deciding whether to dismiss someone with less than 2 years of continuous employment. Employers who are found to have unfairly treated someone with a protected characteristic during a dismissal will be automatically deemed to have unfairly dismissed the employee. In turn, this could lead to an uncapped compensation award being made against the company, commonly up to 2 years' salary. Employees with over 2 years of continuous employment have an automatic right to request an employment tribunal, and there is no fee required to do so. So there you have it. We hope this video has provided a clear guide to preparing for and handling disciplinary procedures in small businesses. If an informal approach doesn't work, you'll need to schedule a disciplinary hearing and invite all relevant parties, carry out a fair investigation into the matter, and follow up with an appropriate outcome. The key thing for employers to remember about disciplinary procedures is that they must be fair, impartial, and reasonable. You should always compile evidence as if it was being viewed by an outside observer. Additionally, you should consider if the employee has any protected characteristics when deciding your outcome, or if they have over 2 years of continuous service. If you have any questions or comments, feel free to leave them below. We've also included useful links in the description. And don't forget to subscribe to our channel for more business tips and advice. Until next time, cheerio.